Now, the Supreme Court on Thursday resumed its hearing on petitions filed against the Waqf law. During the hearing, the Apex Court has refused to grant an interim stay on the Waqf Amendment Act 2025, but the centre has assured that there should be no alteration in the character of any Waqf property, which includes those registered or declared under the practice of Waqf by user till the next hearing on May 5. Now, the CJI, Sanjeev Khanna, has said that if registration of any Waqf property had taken place under the erstwhile 1995 Act, then those properties cannot be re-notified till the next hearing. Now, the court has also said that all Waqf properties, regardless of how they were classified, must be preserved in their current state until the next hearing. It has also directed that no new appointments be made to any Waqf board during this period. Centre has been given 7 days to file its preliminary response along with the relevant documents. In fact, Centre has also assured the key provisions of the Waqf Amendment Act 2025, including the inclusion of non-Muslims in the Central Waqf Council and the Waqf boards and the provisions on denotifying properties, which has been declared as Waqf by courts, and this will not be acted upon for the time being.
Is intended in any manner to prejudge the issue, which has been heard at length yesterday and today, and will also be heard for further interim relief, etc. on 5th. But I will try to the best of my ability scrupulously to separate the political and the legal. But focusing more on the political, I wanted to say, and part of this we have said in Parliament, I had occasion to speak in Parliament. My able colleague spoke very well and very strongly in Parliament. So I wanted to say, friends, that this is not reform. It is retaliation in the guise of reform. It is retaliation meticulously scripted, strategically timed, and constitutionally questionable. The Waqf Amendment Act is not an exercise in efficiency as it pretends to be. It is an exercise in erasure. Behind the bland language of governance lies the bold ambition of control. Religious autonomy is being reduced to state-administered protocol, and community rights are being redrawn with bureaucratic pens. Let us be clear, this is not about improving institutions, this is about infiltrating them, controlling them, and closing them.
The Supreme Court has said that the Central Waqf Council and the State Waqf Boards will not be constituted. Waqf by user cannot be deleted. Now, there are other provisions also which we as a party have come to the Honorable Supreme Court that calling it unconstitutional. Now, whenever it will be heard, our counsel, Mr. Nizam Pasha, on behalf of me, will be arguing it. As you know very well that during the deliberations of the Joint Working Committee, I have given a Dyson report opposing all the amendments that were proposed by the government. And during the debate in the Parliament on the consideration or passing of that bill, I have opposed each and every amendment. I have called it unconstitutional. I still call this law as unconstitutional, as violating the fundamental rights of Article 14, 15, 25, 26 and 29. So our legal battle will continue to ensure that this act, against this act will continue.
कि आज हम सुप्रीम कोर्ट का तमाम जजेस का तहे दिल से शुक्रगुजार हैं कि आज हमें यहाँ इंसाफ मिला। हम तमाम वकीलों का, जो वकील भी पेश हुए, हमारे वकील और तमाम सीनियर वकील, वो सारे वकील पेश हुए, उन तमाम वकीलों का हम शुक्रगुजार हैं। और हमें सुप्रीम कोर्ट से यही उम्मीद थी कि फैसला हमारे हक में आएगा। जिस तरह से आज केंद्र सरकार के वकील ने कहा, कल जो जज साहब ने बात कही थी कि हम जो वक्फ बाय यूजर प्रॉपर्टी हैं, इनके साथ कोई छेड़छाड़ नहीं करेंगे, रजिस्ट्रेशन में किसी किस्म का कोई छेड़छाड़ नहीं करेंगे, और जो वक्फ बोर्ड जो बनाएंगे उसमें किसी मेंबर को ना ऐड करेंगे, ना ही कोई मेंबर हम बनाएंगे, ना ही कोई वक्फ बोर्ड जो है हम फॉर्म करेंगे। तो 8 दिन का 28 तारीख को नेक्स्ट हियरिंग है, उसके बाद 5 दिन।
Mr. Sankla, for the center, is it the case of glass half empty or half full?
Very well said. No, not really. You see, there is a concept called list that we are aware of. Once a matter is pending in the court does not want any sudden changes or movements in favor or against. So there's a concept called status quo without status quo actively being provided. This is the same case. The Honorable Supreme Court said that we are perhaps in agreement with certain parts of the amendment. Certain parts of the amendment requires more discussion. Certain part requires convincing, and I'm paraphrasing. And therefore, the center replied that we do understand, but at this moment, this is what our stand is. The court in retaliation stated, yes, that might be it, but we are worried that these changes may be made into effect, which would be difficult to reverse. Again, I'm paraphrasing. And the central government therefore said, till the next date of hearing, we will not do XYZ in terms of the amendment, which satisfied the court, and the court has given the next date of hearing. So therefore, there is nothing that has actually moved in the wrong direction. In fact, I think it is a movement in the right direction. They say that there is a difference between a registered Waqf and an unregistered Waqf. They say that we do understand that the embargo of 5 years before somebody gives away his property to the Waqf perhaps may be a step in the right direction. So therefore, I think it is a positive step. It still requires a lot of discussion, and we will see how it plays out in the Honorable Supreme Court.